Hi, good afternoon, viewers. This is Adil Farooq, and you are watching Legal Lounge with Adil Farooq. Thank you very much to be with me on this live session, and I received very positive response from many of my viewers, my clients, my friends, and my family. And they always request me to come up with new topics and new ideas. I will also request all of you, if you want me to cover any specific legal point, please tell me, and I will try my best to come up with the information what you are looking for. Recently, one of my viewers, she requested me to talk about probate. I know we have already talked about the wills and power of attorneys more than once, and now today, upon the specific request of one of my clients and viewers, I will be talking about the probate in Ontario. Before we start, is a standard disclaimer that this information session is only for information purposes, and please do not apply the information which I'm giving to you on your specific circumstances. You have to talk to one of your legal representative and discuss with your specific legal issues before you take any action in your specific matter. And you can always contact with our office, and we will be happy to assist you with your legal issues. And we will be in this industry for more than 20 years, and we know many legal aspect which a normal person is unable to understand. That's the reason that we are here to help you. So coming to the point, for the probate, first of all, you should understand that what probate means. Probate means that to process your will after the death. So if someone passed away, then if that person has a will, or if that person has no will, means that person died intestate, we have to process a probate. We have to do the probate process to deal with the deceased's assets. So let's talk first about you guys assuming that a deceased has a will. In that case, when the deceased will pass away, as a trustee, it's your responsibility to take care of all of his assets and distribute the assets as per the terms of the will. So the first thing you need to do to locate the original will. Remember, that's very important, that you guys should have the original will. If you don't have the original will for some reason, then you should be in contact with your lawyer who prepared that will, and that lawyer will be happy to give you that notarized certified true copy. So yes, just 1 second, I have to do a certain, okay, I think that's fine. So now just to assume that you guys that trustee is able to find original will, and that trustee should contact with two individuals, two professionals, I would say. One should be your lawyer, and one should be the accountant. It is very important that the trustee engage an accountant, so he or she can give instructions to the accountant to start the process of filing the last return of the deceased. Also remember that the deceased last return become due right after the death. You don't need to wait for the end of the year, and usually you guys have 6 months from the date of death to file the final return of the deceased. And in that respect, your accountant should be in a position to guide you how to do that process. So side by side, you need to retain a lawyer who will take your original will, and then the lawyer will prepare all the required documents which we need to file in the court to get a certificate of appointment of state trustee. That is called the probate process. And there are two kinds of probate processes. One is for the small estate, and one is for the large estate. Small estate means that state which has less than $150,000 of value. That is called small estate. So that small estate has a little bit different process as compared to the regular estate, which has value of more than $150,000. That's, of course, you, with the help of your accountant and with your lawyer, both of you will see that what is determined, that what is the value of the estate, because this is also important to understand that being a trustee or executor, it's your responsibility to make sure that you paid all the debts of the deceased, and you know that what are the assets of the deceased, which includes anything which has any value. For example, the real estate property, the any vehicle, any boat, any jewelry, any expensive item which should be transferred through the will. So whatever will be transferred to the will, we have to include in our probate application. And once we include in the probate application, we have to pay 1.5% of the value of the estate as a probate fee in the court. The first $50,000 are exempt from the probate fee, so it means this 1.5% will start from after $50,000 and whatever the amount you have. For example, if you have the estate value is $1,050,000, so the $50,000 will be exempt. So probate fee will be payable only on the $1 million, and that will be 1.5%, approximately $15,000 will be the probate fee at that time. So once your lawyer will have all those information, that your lawyer should prepare the required documents which we have to file in the court, and we will get together everything. We will prepare the check payable to the court, and we will submit the probate application in the court, and the court will process the probate application. Remember, there are certain legal requirements which your lawyer should follow while doing the probate process, which includes to serve the documents and serve the application to certain individuals who are or who may be entitled under the under your will, and also if there are any minors, if there are any individuals who have a disability, so we have to involve the the Office of Children, and we also involve the trustees if there are someone who has a special needs in terms of their health issues. So there are certain protocols which we have to follow to complete that process. And once we file the application, there will be chances that someone show up and they will contest your application, and if that application will be contested, then it's a judge who will decide and make a decision on the person whoever contested your probate application. But if that probate application will not be challenged, so it means then it will be processed smoothly, and within few weeks, sometimes within few days, it depends on the urgency of the matter and the court in which court you are filing, the judges will issue you the probate certificate. So this is the standard process for the applications where we have a will. But sometimes the deceased fail to write a will before their death, and the beneficiaries have to struggle to divide the assets, and if this is the case, then there are many other documents which we lawyer have to follow, and of course that will create more complications in the process, and that will usually increase the legal fee of your lawyer as well. So once you have that probate certificate, whether it is with the will or without the will, then you will step into the shoes of the deceased. So usually it is the trustee who apply for that, and if there are more than one trustees all together, they have to be on the same application as the co-applicants, and the judge will issue a probate certificates to all of them. So once the probate certificate is issued, then you can deal with all the assets of the deceased. If there are any real estate properties involved, that real estate property is first transferred to the trustees, and from the trustees to the beneficiaries. If they are selling, the beneficiaries are selling those assets, they can directly sell it from the trustee to the new owners, and the trustee will take care of the division of the money which they will receive after sale of the property. So these are the standard protocols. And if there are other issues, for example, if there's a corporation, the trustee has to take care of this corporation as well, or any other assets which the deceased left, and that trustee has to deal with those assets as per the terms of the will. So in terms of the division, that trustee has no choice but to divide the assets as per the terms of the will. But if somebody challenges that will, because if one of the beneficiaries was received less than what they're expecting, then of course they can come and challenge the will. And then if that will be the case, then it's a long process. Then it's the court who will decide if the division of the asset should be as per the will or as per the new court order, whatever the court will determine. So this was a very brief introduction of the probate process, but it is not as simple as it looks like. There are sometimes legal complications comes in, and there you need an opinion or input from an expert lawyer who has knowledge of the probate process. As you guys can always contact our office. We are conveniently located in Mississauga near Square One. And you can send us an email at adil@adillaw.ca, or you can call our office, which is 905-502-7474. So let me see, my viewers, if I have any questions from my viewers. Right, and while I am checking, just give me 1 minute, please. So yes, I have a very basic question which I already answered, but I will repeat myself. A viewer of mine said that if the trustees failed to locate the original will, how they will deal with this matter. So in that case, you guys have to find out that who is the lawyer who prepared that will and contact that lawyer. Mostly that lawyers keep a copy of that will, and those lawyers can issue a certified true copy of the will, which you can use for that process. How to do that? That's your lawyer will advise you that how to do that. Okay, and I have another question. Here you go. So the other viewer is asking me if there are more than one trustees in the will, how they can do the process. So it all depends then how the deceased set up that trustees. If that trustee is an alternative trustee, means if there are more than one trustee on the first level, let's say the first child is a trustee, then as an alternative the second child is a trustee, then the first child will have the right to be a trustee of this process on the first level. But for some reason, if that son or whoever the trustee is not available, then the second person can come into the picture. But in that case, your lawyer has to get a waiver or the consent of the first trustee that he is not interested to be part of this one, so it will switch to the second trustee. But remember, sometimes the deceased write two trustees together, like these two sons or two children of mine will be the equal trustee or the trustee on the first priority. Then both of them should be the applicant of the trustees, and both of them should work together, and both of them should agree on the same thing before to take any action. If in this kind of situation you guys are running into a risk that if one of the trustees realize that this like I said, if there's a dispute between two trustees that what is good for the state, then most probably this matter will end up in the court, and trustees will be taking instructions from the court at the state's expense, and that may create a problem for the state as well. So I believe that's all for now today. But remember that always take advice from your legal professional before you take any action. Guys, thank you very much for watching. Always, I will see you next week, same time, same platform. Don't forget to like and follow me and subscribe on my channel as well, and see you next week. Take care. Bye bye.